Bonjour. 1, 2, 3.
Good morning, everyone. Good morning, everyone. First, on behalf of Cedar Centre for Legal Studies, I am delighted to welcome those joining us today in person at the Geneva Press Club and those participating online. First, we should have our moderator, but she is a bit late. First, thank you for being with us today to discuss the role of Universal Periodic Review in advancing human rights and combating torture in Lebanon. Before we begin, I would like to thank Heinrich Böll Foundation, Beirut office, for supporting us in this event. Also, one note, for those attending online, there will be translation available from and to Arabic language. First, I would like to let my colleagues, the speakers here, to speak about themselves, everyone. For myself, I am Saadidin Shetila, the director of Cedar Centre for Legal Studies. As a brief, but then I will speak about it in my PowerPoint. I will let my colleague Meva.
Thank you. Good morning, everyone. So my name is Maeva René-Barry, and I work as UN Program Manager for the IRCT, the International Rehabilitation Council for Torture Victims. The IRCT is a membership organization comprised of more than 170 centers of rehabilitation across the globe. We have members in more than 80 countries, from Latin America to Africa to Asia to Europe, and also in the North America, in Canada and the US. So we've been active for more than 40 years, fighting against torture, providing rehabilitation for torture victims. We have developed several programs around our two key pillars, healing and justice. So our goal is really to advance the situations of torture victims by providing them with adequate rehabilitation, with also
recording in progress,
with also a livelihood support, because when a person has suffered from torture, usually they have lost their system of support in terms of income. So it's been also important for us over time to develop this kind of livelihood support in order to allow the survivors to regain autonomy. So that was the healing part, but we also work on justice, and this is where my work as advocacy officer and UN program manager fits in, because here, based in Geneva, I'm in charge of the engagement that we do with UN mechanisms. We work a lot with the Committee Against Torture, the committee that is responsible to monitor the implementation of the Convention Against Torture. So we support our members when their state is going under review to be able to assess the implementation of the convention in their state and to formulate recommendations that will then hopefully be made by the committee to their state. When those recommendations are made, we help our members to develop partnerships at the national level to implement those recommendations and make sure that the issues relating to torture are being addressed. We also support our members in the UPR reviews, so Universal Periodic Reviews, and I know that my colleagues on the panel will touch more on this subject during today's event. Well, thank you very much, and looking forward to tell you more on my work later.
صباح الخير جميعا. المحامي محمد صبلوح، مدير البرنامج القانوني لمركز سيدار للدراسات القانونية. أعمل على توثيق انتهاكات حقوق الإنسان في لبنان. اليوم بمناسبة اليوم الدولي لمساندة ضحايا التعذيب، دائما نعمل على وضع خطة عمل لمكافحة جريمة التعذيب في لبنان. التعذيب في لبنان ممنهج بغطاء قيادات أمنية وبغطاء قضائي للأسف. سنفصل اليوم عن بالأدلة القاطعة لماذا التعذيب في لبنان ممنهج. نأمل أن نستطيع من خلال هذا المؤتمر اليوم أن نوصل واقع المظلومين في لبنان وضحايا التعذيب لنعلمهم أننا موجودون دائما دعما لهم ولرفع الظلم عنهم. نتمنى أن تكون قادمات الأيام في لبنان نرى تغييرا حقيقيا، نرى ثقافة العنف التي مبنية على انتزاع الاعترافات بالقوة وضرب الناس أن تتغير حتى نفتخر بلبنان الذي جميعنا ننتمي إليه. شكرا لكم.
Yes. Hello. This is Michael Kambata here. I'm the Geneva representative for the Gulf Center for Human Rights. The Gulf Center for Human Rights was founded in 2011, and we document violations in the Gulf states and increasingly in the rest of the MENA region. My job here is to engage with the United Nations human rights mechanisms, in particular the UPR, and I've participated in a number of them, and we'll be happy to discuss further when we give our presentations.
Good morning. My name is Samira Mouassi. I work in the Office of the High Commissioner for Human Rights here in Geneva, more precisely in the Civic Space Unit, in the Thematic Engagement and Special Procedures Division. Thank you.
Okay, so I will begin my PowerPoint presentation. I will try to brief a bit about the Cedar Centre for Legal Studies. It's a Lebanese human rights NGO established in Lebanon in 2013. We are independent, non-sectarian, and we focus on protecting people whose rights are violated. Our main work include documentation of torture and ill treatment, arbitrary detention, enforced disappearance cases, migrants and refugee rights, trial monitoring and legal aid. So we have two main programs. First one is regarding rehabilitation. So we have a rehabilitation team in north of Lebanon. And other one, we have a legal team. So this is the other program. First one, regarding rehabilitation program, so we provide medical services, psychosocial support, and physiotherapy as well. So some numbers about our services. Until now, in our rehabilitation center, we had provided 266 medical consultation and physiotherapy sessions and 612 psychosocial sessions. Regarding the other program, which is related to legal protection and global advocacy, so we provide legal assistance, and my colleague Mohammed will speak more about it, and case documentation, and there is UN and international advocacy. We for instance, we submit cases to the UN mechanism. So as a general situation, before going to UPR process, I would just speak a bit about general situation in Lebanon. Lebanon continues to face a major political, economic, and institutional crisis. For instance, as well, there was a recent armed conflict in Lebanon, and there was ongoing regional tension has placed additional strain on state institutions. For this reason and other reason, Lebanon hasn't submitted or published many reports and hasn't submitted its regular report to the UN. Like for instance, for a subcommittee on prevention of torture, Lebanon hasn't submitted the SPT visit to Lebanon in 2010 and 2022. SPT is like a subcommittee of UN prevention committee, but that make it easier for violation to happen. As a timeline for UPR process, there was in September 2025 national consultation, and before, like in July, there was submission of stakeholder reports, which also we submitted our report, and other NGOs submitted their report as well. And in October 2025, there was a state report as well. In January 2026, there was the UPR review of Lebanon, and on 30th of June, there will be the adoption of Lebanon report next week. So also some recommendation that I want to highlight, that is important to highlight about Lebanon and torture. There was a recommendation by Croatia, Denmark, and Switzerland and Gambia called Lebanese authorities to fully implement the anti-torture law, because now my colleague will speak about it, that although we have like since 2017 an anti-torture law, but it hasn't been really implemented. So those countries asked to fully be implemented, and also there was other important recommendation regarding military court, that it should be limited just to military members. So this state were Germany, Canada, France, and Sierra Leone. And the other one, it is related to national human rights institution and info disappearance. So states like Chile, Japan, Bulgaria, and Denmark has called Lebanon to give more power to the national human rights institution, and also to ratify the Convention of info disappearance. So just some remark about the Lebanese report that was submitted to UPR, that every time it's like a general narrative of progress that they are saying, that we are doing work, and etc., etc. That they have all laws that like torture law that was issued in 2017, and there was another law in 2018 on missing, so that already they have this legal framework. But also they say that we had some challenges caused by economic crisis, COVID-19, and Beirut port explosion. So that in summary what they say. But what we have noticed as gaps in this report or in their national report, that laws are in place, but implementation is limited or absent. We see that we have like that anti-torture law or that missing law, but actually they are not implementing these laws, good laws. Torture cases are still being sent to military court, which also therefore there was no serious investigation about these cases. So that was another issue. For this reason, the civil society were asking to limit the competence of military court. Article 47 also my colleague will speak about it, which is a very important article. Also, it's, although we have this article, but it's never been implemented in many cases. Disappears remain uninvestigated despite law number 105. So, as a final remark, as you might know, that Lebanese authorities sent the response of to the recommendation in like last week, and for this reason they will present in the next session in 30 June what they have agreed and what they haven't agreed. But in summary about recommendation, like regarding amending the current anti-torture laws, they have supported this recommendation. Regarding military court, actually, no, they have took note, and they haven't supported this recommendation. And regarding national human rights institution, they have supported that they want to make it more, give it more capacity and power. But regarding import disappearance, they have noted on ratifying this convention. So that summary of my PowerPoint, and thank you. And also I would like to welcome our moderator, Maisa. Before to skip to my colleague PowerPoint, we have made, like it was just yesterday, we have finished a video about 2 minutes. It speaks a bit about 2 cases. So let's watch it, and then we can go to another PowerPoint. Thank you.
بشار عبد سعود شاب سوري زوج وأب ل3 أطفال، رفض أن يكون جزءا من القتل في سوريا، فهرب إلى لبنان بحثا عن الأمان، لكن الأمان انتهى داخل الاحتجاز. محمد حرقوس شاب لبناني زوج وأب ل2، خرج ليؤمن رزقه فعاد إلى عائلته جثة، وبين بشار ومحمد حكاية واحدة: تعذيب، موت، طمس وإفلات من العقاب. في بيت بشار عبد سعود لم يعد طرق الباب حدثا عاديا، كلما سمع صوت الباب يركض أطفاله نحوه كأنهم ينتظرون معجزة واحدة: عاد بابا. لكن بشار لم يعد. ذات مساء عند الساعة 8 دخل عناصر أمن إلى دكانه واقتادوه من دون تفسير. بعد 3 ساعات فقط كان بشار قد فارق الحياة، وبعد يومين طلب من عائلته استلام جثته من براد مستشفى. قدمت العائلة شكوى، طلبت بتحقيق عدلي، وقدمت أدلة على تعرضه للتعذيب الوحشي، لكن الملف دفن داخل القضاء العسكري. رفضت الأدلة وأدين المرتكب بجنحة رغم أن التعذيب جناية لا تسقط بمرور الزمن، ثم أخلي سبيل المدعى عليهم. أما الضابط المسؤول فبدل أن يحاسب أصبح لاحقا في موقع أمني رفيع داخل أمن الدولة. هنا لم تمت الضحية وحدها، ماتت العدالة معها، ولو حسب من عذب بشار ربما لم تكن الجريمة لتتكرر، لكنها تكررت، والضحية التالية كان اسمه محمد حرقوس. محمد أب ل2، اقتيد من طريق المطار في الضاحية الجنوبية، وفي اليوم التالي تسلمت عائلته جثمانه من المستشفى العسكري. حاولت الرواية الرسمية أن تختصر موته بعوارض صحية، لكن جسده كان يحمل أسئلة لا يمكن دفنها، فبحسب ملحق التقرير الطبي الشرعي وتقرير الأشعة ظهرت إصابات خطيرة نزيف دماغي حاد، تجمع دموي تحت الجافية، ووذمة دماغية منتشرة. هذه المعطيات لم تكن تفصيلا طبيا عابرا، كانت سؤالا مباشرا إلى العدالة. ماذا حدث لمحمد أثناء الاحتجاز؟ ومع ذلك لم تتعامل النيابة العامة العسكرية مع ما حصل كجريمة أصلا. لم يحاسب الفاعل، ولم تبدأ محاكمة حقيقية من بشار عبد السعود إلى محمد حرقوس. يتكرر المسار نفسه: توقيف، تعذيب، موت، تبرير، طمس، وإفلات من العقاب. حين لا يحاسب الجلاد في الجريمة الأولى، يصبح الطريق مفتوحا لجريمة ثانية. وحين تتحول المؤسسات إلى جدران صمت، تصبح العدالة ضحية ثالثة. فمن يحاسب من يعذب في لبنان؟ ومن يوقف الجريمة قبل أن يصبح لدينا بشار جديد ومحمد جديد؟ ومن يعيد بشار إلى أطفاله؟ ومن يعيد محمد إلى طفلتيه؟
Okay. Good morning, everyone, and apologies for being late today. My name is Maisa Ashaq, and I'm Advocacy Officer at the Cairo Institute for Human Rights Studies. I will just say a few words to frame our discussion today before we move on to our next distinguished panelist. This discussion is happening because the Lebanon's UPR outcome report is scheduled for adoption at this very session. So it is a reminder that the commitments made in January in the working group and the recommendations accepted by Lebanon and the pledges given will be inscribed at these councils. And it's also the right moment to ask what has actually changed in Lebanon and what must the international community continue to scrutinize and to follow. Today we will have a focused discussion on torture in Lebanon, and our distinguished panelist Mohammed will tell us more about this. But it is very important that any discussion we have today on Lebanon is understood within something structural, which is a political system that has consistently prioritized the preservation of elite arrangements over the accountability of state actors. And we cannot also understand impunity in Lebanon without understanding the economic and social context in which it is embedded. And how these different crises are affecting individuals unequally in Lebanon. So it is in this context in which this UPR cycle must be read. The recommendations that will be discussed on torture preventions, on detention safeguards, on access to justice should be met with real action by the authorities. We will start this discussion on torture in Lebanon with our distinguished panelists. Mohammed, you have the floor.
صباح الخير جميعا. شكرا لكم على الحضور اليوم، وإن شاء الله نقدر نكون بالعرض اللي اليوم بدنا نحطه نحن مش عم نقول شيء نظري. نحن اليوم عملنا تطبيقنا على الأرض على مدى سنوات بيأكد موضوع القوانين كيف تشرع في لبنان ومين عم ينفذها. فنأمل نكون نوصل الفكرة ونقدر نتساعد جميعا لنوصل ببلد يشرع قوانين وينفذها. نحن كمركز سيدار للدراسات القانونية من سنوات عملنا خط ساخن. خط ساخن لأي شخص بيتعرض لانتهاك، سواء تعذيب أو اختفاء قسري أو اعتقال تعسفي أو حالات توقيف وترحيل، وهيدي مارسناها على مدى سنوات قبل سقوط نظام بشار الأسد. لأنه للأسف الأجهزة الأمنية اللبنانية وبطريقة مخالفة للقوانين كانت تعمد إلى تسليم ضباط منشقين عن نظام الأسد إلى نظام بشار الأسد، وعدد منهم كبير تم إعدامه. خلينا نذكر الناس اليوم أنه اتفاقية مناهضة التعذيب وقع عليها لبنان عام 2000. وقع عليها عام 2000. كان مطلوب منه عام 2001 يعمل أول تقرير. أول تقرير قدمه لبنان عام 2016. بهالوقت نحن كمحامين، أنا لليوم بترافع بالمحاكم العسكرية والعدلية والجنائية، بستند لاتفاقية مناهضة التعذيب. بيسألوني القضاة منين جايبها. حتى اليوم اللي نحن قاعدين فيه هون في قضاة ما بتعرف شو معناتها اتفاقية مناهضة التعذيب. وهذا بيأكد إنه لبنان بيوقع على اتفاقيات يا إما بعمي مع القضاء، يا إما بنوقع بس حتى نحن نقول وقعنا على اتفاقيات دون أي نتيجة. نتيجة التوثيق اللي عملوه المنظمات الحقوقية والمحامين ألزم لبنان على تعديل قانون تجريم التعذيب أو تشريع قانون تجريم التعذيب. وبلشت نحن بموضوع القانون 65 على 2017. يومتها نتيجة الضغط اللي عملناه على المجتمع الدولي، كل 4 سنين بيصير في مراجعات دولية مع لبنان بالUPR بالمجلس حقوق الإنسان بالأمم المتحدة. نتيجة الضغط اللي عملناه مع المنظمات الأخرى مش لوحدنا، قدرنا نضغط على لبنان ليشرع قانون التعذيب. عندما شرع قانون التعذيب رقم 65 على 2017 ب 19 أيلول 2017 نحن كحقوقيون عملنا احتفالات في لبنان واعتبرناه نصر للعدالة. لكن اليوم بالعام 2026 هذا القانون هو حبر على ورق. كل الضغوطات اللي عملناها، كل الإنجازات اللي اعتبرناها قدرنا نوصل وجع الناس، شرع لبنان المجلس النيابي قانون تجريم التعذيب يلي نحن والمنظمات الأخرى وضعوا العديد من الانتقادات حوله. يعني في عنا انتقادات على في مطالبات ببعض التعديلات على الرغم من انتقادنا عليه، لكنه حتى بوجهه الحالي لم يتم تطبيقه. هذا بيأكد أنه لبنان انضم لاتفاقية مناهضة التعذيب، شرع قانون تجريم التعذيب، بس هذا التشريع هيدي الانضمام كان بلا أي نتيجة في لبنان. ونحن حنقول هلأ ليش ما في نتيجة. في إشكاليات بالممارسات لما نحن كمحامين كحقوقيين عم نواجهها، وبتأكد أنه لبنان لا ينفذ القوانين اللي هو المفروض على الجهاز الأمني، على الضابطة العدلية، هي عم تلاحق الناس اللي بيخالفوا القوانين. فتخيلوا بلبنان الضابطة العدلية المولجة تطبيق القانون هي عم تخالفه والقضاء عم يغطيها. عندنا المادة 47 أصول محاكمات جزائية، كمان لبنان عدلها بناء على طلبات المجتمع الدولي، وتم تعديلها لإلزامية حضور المحامي التحقيقات الأولية والاستفادة يتصل بأهله على ما بيتوقف. نحن اليوم بال2026 أحيانا بيختفي اللبناني أو الأجنبي في لبنان 15 يوما، ما بنعرف عنه شيء نهائيا لحد ما نبرم عليه ونرفع دعوة اختفاء قسري لنعرفه عن جهاز أمني. وهذا بيأكد أنه المادة 47 ما عم تطبق. كمان عندنا المادة 32 أصول محاكمات جزائية يلي وضعت سقف للتوقيف الاحتياطي عند الضابطة العدلية اللي هو يومان، قابلة للتمديد بقرار من النيابة العامة معلل يومين آخرين. يعني المفترض الموقوف يقعد 4 أيام عند الضابطة العدلية، نحن اليوم بيقعد شهر لضمان زوال آثار التعذيب ولا بنعرف عنه شيء أحيانا. هذا بيأكد هيدي المخالفات القانونية الجسيمة هي اللي تمنع تطبيق قانون 65 على 2017، هي اللي بتمنع أو بتعطي حصانة للضابطة العدلية بعدم تطبيق اتفاقية مناهضة التعذيب، بعدم تطبيق قانون تجريم التعذيب، واللي بيخلينا نوصل للي نحن وصلنا له. اليوم اسمحوا لي أقول، وأنا بأسف لازم أوقف هون وأفتخر أنه بلدي عم يطبق القوانين، اسمحوا لي أقول أنه الضابطة العدلية في لبنان تحاول الالتفاف على المادة 47 أصول محاكمات جزائية. يعني مخابرات الجيش اللبناني هم ليسوا ضابطة عدلية. مخابرات الجيش اللبناني بالمناطق بيخطفوا الناس، بيعرضوهم لأبشع أنواع الضرب والتعذيب. في ختم موجود عرض عليه الاستفادة من المادة 47 أصول محاكمات جزائية فرفض أن، يعني تخيلوا الموقوف بيرفض يتصل بأهله يقول لهم هو وين، بيرفض يتصل بأهله يقول لهم بدي محامي. والمشكل أنه كل موقوفي لبنان ما بدهم هيدي اللي يستفيدوا من هالمادة، فبحققوا معه تحت الضرب والتعذيب. واليوم أنا بقولها وقلتها بالإعلام اللبناني، اللي شفناه بصدنايا بالشام موجود بمخابرات الجيش بأبلح، موجود بمخابرات الجيش بشمال لبنان، موجود بمخابرات الجيش بالضاحية، موجود بمخابرات الجيش بالجنوب. للأسف بيحولوا الملف بعد ما يخلصوا عند الشرطة العسكرية، بيكون الموقوف خلص كل شيء، تجي عند الشرطة العسكرية بيقولوا له أنت ماضي على محضر استرجي غيره، هو موجود عندهم. هيدي الأساليب الالتفافية هيدي بتأكد أنه اليوم مرتكب جريمة التعذيب ومخالف القوانين عم ياخذ حصانة قضائية. طيب مشان ما نكون كمان عم نسلط فقط على مخابرات الجيش، كمان للإيجابية اللي الواحد يقولها بوزارة الدفاع بيحاولوا يبينوا انه غير. لما بيتحول موقوف على وزاره الدفاع، انا بيتواصلوا معي ضباط بوزاره الدفاع بيحاولوا يبينوا انه هن غير وعملوا سجن نموذجي. لكن التغيير الحقيقي يجب ان يبدا من غرف صيدنايا الموجوده عند مخابرات الجيش بالمناطق. 2. معلومات قوى الامن الداخلي. نحن لما اجى التغيير وصار في قيادات امنيه جديده، معلومات قوى الامن الداخلي بالاشرفيه اللي هي المركز الاساسي تاعهم هي صيدنايا اخر. أنا حقلكم حالة واحدة، رحت لطبق المادة 47 بمعلومات قوى الأمن الداخلي منذ أشهر، بيقولوا لي ما بده محامي، مع أنه أنا عامل وكالة ومتفق مع عائلته وكل شيء. بقوم بعمل فيديو على السوشيال ميديا أمام المديرية قوى الأمن الداخلي، مدعي عام تمييز بيقول لي محمد لا عملت فيديو، قلت له لأنه عنده هيك رفضوا تطبيق المادة. قال لي اطلع طبقها، بس قال ما تطلع أنت لأنه منهم طايقينك. لقالي بعت محامي من مكتبك. بعت محامي من مكتبي لنشوف الموقوف، 3 أيام بلا أكل وشرب. لما حطوا له فنجان شاي عذرا ما بقى يقدر يكمش بإيديه، قاعد يلحوس بلسانه نتيجة الضرب والتعذيب. طلبنا فتح تحقيق، مدعي عام تمييز ما فتح تحقيق. قال لي ما تعمل شيء على السوشيال ميديا، عهد عليه بفتح تحقيق، ما فتح. هيدي معلومات قوى الأمن الداخلي. طيب أنا بيقولوا لي البعض مدير المعلومات آدمي العميد أبرص، قلت له آدمي ما له سلطة على المعلومات. هيدا مشكلتنا. كذلك الأمن العام، الأمن العام اللبناني بمعلومات الأمن العام بمراحل سابقة كان عم يمارس نفس الأساليب. أمن الدولة شفنا بشار عبد سعود، وبالتالي هيدي ثقافة عم يحاولوا الالتفاف على المادة 47 مشان يعني بطريقة مخالفة للقانون ليغطوا جرائم التعذيب. مهم. أما اليوم يعني بدنا نكون كمان شفافين. أنا التقيت مع مدير عام الأمن العام وقال لي عندنا مخالفات قانونية جسيمة دلني عليها، وعم حاول دله عليها، وفي تعاطي إيجابي بحد ما إلى حد ما بمعلومات الأمن العام. بأمل ما يكون شخص يكون معمول لكل الناس، وعم نحاول نغير ثقافة التعذيب. وبتمنى كل الأجهزة الأمنية تخطو هيدي الخطوة لنقدر يعني نوقف هذه الثقافة اللي هي ثقافة لانتزاع الاعترافات بالقوة. فاليوم عندنا عدم التزام بالمهل القانونية، عدم الالتزام بالمادة 47 والمادة 32، وهذا بيؤدي لاستمرار التعذيب، لأنه المحقق صار معه حصانة مطلقة وبيقدر يعمل بده إياه بضحية الموقوف اللي هو ضحية التعذيب. نحن وشو عم نعمل هون؟ عم بيجي مدعي عام تمييز، عم نقدم له طلب تعيين طبيب شرعي، بينطر 10 أيام ليعين، ولما بيعين طبيب شرعي بيطلع بيشوف التعذيب بعيونه وبيقول لي أنا بدي أوقف بشق الأجهزة الأمنية ليكون صالح. وهذا الشيء صار معنا ببشار عبد سعود، وصار معنا بمحمد حقوق اللي بنحكي فيه. فعندنا مشكلة نحن اليوم بلبنان ومنقولها، لا يوجد أطباء شرعيين متخصصين. الأطباء الشرعيين الموجودين اليوم في لبنان مكلفين من وزارة العدل، والآدمي فيهم بيقول لك يا أخي ما تعلقني مع الأجهزة الأمنية، ما بدي أكتب تقرير. للأسف. وأنا اليوم اسمحوا لي وجه شكري للمقرر الخاص المعني بجرائم القتل خارج إطار القانون الدكتور موريس اللي زار لبنان ووضع إيده مباشرة عبر لقائه مع رئيس الحكومة على موضوع غياب الطب الشرعي في لبنان، لأنه تقدم عدة مشاريع قوانين لموضوع الطب الشرعي، لكن للأسف كلها رميت بالأدراج. اليوم المقرر الخاص عمل دراسة كاملة لإنشاء معهد للطب الشرعي، وعم يحاول يعالجها بالتعاون مع الحكومة اللبنانية، لأنه إذا بلشنا صح بمعالجة موضوع الطب الشرعي في لبنان كمان بنقطع شوط كبير بموضوع مكافحة جريمة التعذيب. بدنا أطباء شرعيين شرفاء، بدنا أطباء شرعيين عندهم حصانة ما بيخافوا من أجهزة أمنية تنتقم منهم إذا عطوا تقرير ضدها. أنا من أسبوعين طبيب شرعي طلع على فصيلة بقوى الأمن الداخلي بالبترون، عيط على الموقوف، قالوا مين قال لك تعيط بوجه الأجهزة الأمنية يا عيب الشوم عليك؟ لو في تعذيب حقول ما في تعذيب. هذا طبيب شرعي بلبنان. فنحن اليوم بأمس الحاجة لموضوع الطب الشرعي. والمقرر الخاص لما زار لبنان، زارنا كمكتبنا بسيدار دكتور موريس، كان عم يقلنا على موضوع جرائم القتل خارج اطار القانون يلي صارت. يعني عندنا مثلا نحن مركب نيسان غرق 40 شخص بتصرف من ضابط وعناصر بالجيش خاطئ، طمست الحقائق وحفظت الدعوة. منذ 3 أشهر ضابط بأمن الدولة بشمال راح عم يعتقل شخص، لقاه وقف بوشه، حمل الفرد وقوصه، نزل ميت على الأرض. عريس عرسه بعد 3 أشهر وحيد لأمه. أمه كل يوم عم تعتصم قدام قصر عدل الحلبة. النيابة العامة العسكرية طمست الحقائق واعتبرت أنه ما في جريمة ارتكبت، أو بتتحجج أنه ما في إذن، مع أنه المادة 15 واضحة لا تتطلب وجود إذن حتى تلحق هذا الضابط. فعندنا مشكلة اليوم بالطب الشرعي، وعندنا مشكلة بعدم تطبيق القوانين. نحن كمركز أمام هذه المشاكل شو عملنا؟ عملنا إحصاء. أكثر من 107 شكاوى تقدم بها مركز سيدار للدراسات القانونية تعذيب أمام النيابة العامة التمييزية خلال 2.5 سنين، لم تتحرك فيهم إلا شكوى واحدة، هي شكوى بشار عبد سعود. لا، لأنه أصبحت قضية رأي عام وبينت للناس كلها. وعلى الرغم من أن قضية رأي عام وتابعناها نحن كمركز سيدار مع منظمة العفو الدولية، هيومن رايتس ووتش، المركز اللبناني لحقوق الإنسان، ليجل أجندا، المنظمات والصحافة، كنا نحضر الجلسات. أنا بيقول لي رئيس المحكمة العسكرية بدنا نضب الموضوع، طلب مني مسؤول كبير بالبلد بدنا نضبه، قلت له على جستي ما بينطب. وآخر شيء طمسوا الحقائق، والضابط مثل ما شفنا اليوم يتولى مركز أمني رفيع لأنه ارتكب جريمة التعذيب. هذا الاستمرار الإفلات من العقاب. أنا اليوم من هون من جنيف، هذا أخبار للتفتيش القضائي، 107 شكاوى تعذيب مرميين بالأدراج، لم يتم تحريك ولا شكوى منهم بحجة بدهم يغطوا الضابطة العدلية بارتكاب جرائمها ويعطوها الحصانة الكاملة. شفنا نحن بالفيديو الفرق، بشار عبد سعود عام 2022، محمد حرقوس عام 2026. محمد حرقوس كمان تعليقا على موضوع الطب الشرعي، اجى طبيب شرعي عطى تقرير انه مات ذبحه قلبيه، توقف قلبي رئوي. ثاني يوم اهله بيستلموا جثه بياخذوه على المستشفى، اكل ضربه حاده على الراس، ومبين انه زلمه متعرض لضرب وتعذيب. فالطبيب الشرعي بالمستشفى اعطانا تقرير مضاد للتقرير اللي اعطاه الطبيب الشرعي الاول. هذا اللي بيعطينا اشكاليه، عندنا مشكله بالطب الشرعي، لانه الطبيب الشرعي الاولاني بيخاف من الاجهزه الامنيه وما بده يورط حاله، وانا بيقولوا لي اياها، بيستدعوني على المحاكم وبيقيدوا لي عملي مني مضطر. فنحن اليوم رسالتنا للمقرر الخاص، نتشكر على وقفته الدكتور موريس، ونتمنى نتابع بموضوع معهد الطب الشرعي لانه نحن بامس الحاجه له. نرجع للماده الثالثه من اتفاقيه مناهضه التعذيب. المادة الثالثة من اتفاقية مناهضة التعذيب بتمنع ترحيل أي شخص ممكن يتعرض لتعذيب بالبلد اللي ممكن يتسلم لها. أوقف لبنان بناء على ادعاء نيابة عامة إماراتية من الإمارات، أوقف الشاعر عبد الرحمن القرضاوي بسبب كلام قاله بدمشق. خلال 8 أيام، أسرع قضية بتاريخ لبنان، حكومة الرئيس نجيب ميقاتي سلمت الشاعر عبد الرحمن القرضاوي لدولة الإمارات. لا عطونا فرصة أن نطعن، ولا عطونا أي شيء أن ناخذ نمارس حقنا بالدفاع القانوني عنه. وأسرنا الموضوع بالإعلام، لكن كانوا أسرع منا بكثير وسلموه للإمارات. تقدمنا بطعن أمام مجلس شورى الدولة، عم نقول هذا مخالف لاتفاقية مناهضة التعذيب ونحن ما بنعرف عنه شيء. تخيلوا مجلس شورى الدولة اللي هو أعلى مرجع قضائي موجود كمان بلبنان ما بيناقشني باتفاقية مناهضة التعذيب ولا كأنه بيعرفها، بيقول نحن طبقنا القانون اللبناني. وهذا بيدل أنه القضاء في لبنان لا يريد الاعتراف باتفاقية مناهضة التعذيب. لأنه اليوم مرق 535 يوم على اختفاء الشاعر عبد الرحمن القرضاوي، وهو معزول عن العالم. ما بنعرف عنه عايش ولا ميت، ما بنعرف عنه إذا عم يتحاكم ولا لا، وحسب معلوماتنا معزول حتى بكل سجون الإمارات، ما حدا شافه. أنا من هون أحمل حكومة الرئيس نجيب ميقاتي وحكومة الرئيس نواف سلام وفخامة رئيس الجمهورية اللبنانية العماد جوزيف عون ودولة الإمارات مسؤولية حياة أو موت أو أي شيء بيتعرض له الشاعر عبد الرحمن القرضاوي. هذا الشيء بيخلينا نحن نطلع في غياب الإرادة السياسية والقضائية. ما في إرادة حقيقية للتغيير في لبنان. نتسابق إلى التشريع، لكن ما بنعمل مساءلة أو منشوف إذا نحن فعلا بدنا هالتشريع اللي عم يشرعه المجلس النيابي قابل للتطبيق أو لا. في ضعف بالتحقيقات، في شبهة الإفلات من العقاب صارت عنا وكأن حصانة أعطاها القضاء لمرتكب جريمة التعذيب. أمثلة كثير من 3 سنوات حتى اليوم الصار تعرضوا لأبشع أنواع الضرب والتعذيب. نحن تقدمنا بشكاوى قدام النيابات العامة التمييزية بحلوها أحيانا للقضاء العسكري، والقضاء العسكري بلبنان من أسوأ القضاء الاستثنائي اللي هو بالنهاية لا يمتثل لأوامر القانون اللبناني. طيب نحن أن القضاء العسكري سيء. لما صار في تعديل لقانون 65/2017 تجريم التعذيب، ادعينا أمام القضاء العدلي، قضاء الشمال طرابلس، قضاء بيروت، طلعوا القضاة الموجودين بالعدليين أسوأ من القضاء العسكري. كل ما ندعي بقضية تعذيب بخاف القاضي بضب عجنة، ولا قضية تعذيب تنفتحها. وهذا نحن اليوم أنا بقول هال 107 شكاوى مستعد سلمهم لتفتيش القضائي لنفرجي نحن الانتهاكات اللي عم تتم بغطاء قيادات أمنية وقضائية في لبنان. التوصيات حاختصر اليوم باختصار، حنقول لكم التوصيات. يجب تعديل قانون تجريم التعذيب، تعديله وفقا للإصلاحات أو وفقا للبنود اللي وضعتها المنظمات الحقوقية والتي تتوائم مع اتفاقية مناهضة التعذيب. يعني واحدة منهم جريمة التعذيب لا تسقط بمرور الزمن. في لبنان عطوها مهلة 3 سنين. هيدي لوحدها كفيلة بوجود سوء نية لدى المشرع اللبناني بموضوع هذه الملاحظة. إنشاء معهد الطب الشرعي في لبنان وتخريج أطباء شرعيين متخصصين وفقا للاتفاقيات الدولية، هذا ضرورة ملحة اليوم. إلزام وزراء الداخلية والعدل والدفاع بمساءلة الأجهزة الأمنية والقضائية عن عدم الالتزام بالقوانين ومحاسبة المرتكبين. واسمحوا لي أقول اليوم للمجلس النيابي، النائب ميشيل موسى رئيس لجنة حقوق الإنسان البرلمانية، أنا قدمت له من 2021 مع 24 منظمة دولية، نحن كمركز سيدار طلبنا بمساءلة الوزراء داخل المجلس النيابي، مضى عليها 5 سنين ولم يتجرأ على المساءلة. اليوم دار المشرع اللبناني المجلس النيابي مش فقط التشريع، المساءلة والمحاسبة. أخيراً منحمل الحكومة اللبنانية والإماراتية سلامة الشاعر عبد الرحمن القرضاوي وضرورة الالتزام بحماية المعارضين من تسليمهم لدول ممكن أن يتعرضوا للتعذيب فيها. إقرار القوانين خطوة أولى، لكن جوهر الإصلاح يكمن في تفعيل آليات المحاسبة، تعزيز دور الهيئة الوطنية لحقوق الإنسان، ضمان وجود قضاء مستقل بالكامل يحمي كرامة الإنسان في لبنان. وشكرا.
Thank you, Mohammed. Thank you very much for this very rich presentation, and also for reminding us of 3 essential points that sum up the situation. Lebanon ratified the Convention Against Torture in 2000. It ratified the Optional Protocol 2008. In 2017, it passed the law criminalizing torture, which was genuinely welcomed by all civil society and the international community, rightfully so. Only 7 years after that law has passed, not a single serious prosecution under it has been completed. And thank you also for reminding us that the procedural safeguards enshrined in Article 47 of the Criminal Procedure Code, including the right to a lawyer and to medical examination, are routinely ignored by security agencies. reform that exists on paper while impunity persists in practice is a common pattern across the region. We see it in countries in Libya, in Egypt, in Syria, and Lebanon, as demonstrated today, is one of its clearest illustrations. We can move to our next panelist, Mrs. Maeva René-Barry, to hear more about the survivors chart and the rights-based approaches to torture prevention. Thank you.
Thank you. Yes, it works. Thank you, Chair. Good morning again to you all in person and online. My name is Maeva René-Barry, and I'm with the IRCT, so the International Rehabilitation Council for Torture Victims. First of all, I would like us to remind and be aware that today is the 26th of June, and it's the International Day in support of victims of torture. And so I'm particularly grateful to Cedar Centre for organizing this side event specifically that day. I think it's really symbolic as well, because, well, the whole anti-torture community is really committed to that day, and a lot of events are happening right now around the globe. It's really a day of celebration, but also a day to remind us all that the prohibition of torture is absolute. And we have chosen this day, 26th of June, because it's actually the day that the UN Convention Against Torture entered into force about 40 years ago. But as we know, it's still not completely applied, and shortcomings are visible in all the regions. I already touched upon the work of the IRCT. You know about our two priorities, healing and justice. But I would like to emphasize that we have really a strong network, and in the past year we were able to support more than 70,000 survivors of torture across the globe. In Lebanon, we have several members, so members and close partners, such as the Cedar Centre and such as CLDH. And it's actually with them that we prepared and submitted a joint stakeholder report for the UPR of Lebanon last year. The priorities that I will share now are also an echo of the priorities of our members on the ground. So I've been tasked to talk about the victim-centered approach and the rights of survivors, but I still wanted to start with a few words on the UPR of Lebanon to really frame the issue of survivors' rights into in the context of the UPR of Lebanon. So I will start on this, the UPR of Lebanon. You have already heard a lot on the issues that were raised, but to let you know a bit more on what our partners and the IRCT submitted and advocated, let me focus on three specific points. The first one related to the shortcomings of the law. The law criminalizing torture in Lebanon, the Law 65, as you heard, has several shortcomings which make it not compatible with the Article 1 of the UN Convention Against Torture. One of these shortcomings is that the law only applies to acts occurring during investigations and trials. Another point is that the law comprises statutes of limitation, and some of those statutes of limitations is of 3 years. That means that 3 years after the facts have happened, victims are not able to have it prosecuted. And this is how I want to link it with survivors' rights. Actually, 3 years is a short time when victims are suffering from PTSD, post-traumatic distress syndrome, when they are traumatized, when they are afraid of being re-traumatized by sharing their case and their story to people in the judicial system. 3 years is not enough time to have a complete psychological support and journey, and so that makes it really difficult for victims to bring their case to judges, to the police, especially when the whole system is not always supportive of them, as my colleague explained already. Other shortcomings of the law rest in the fact that penalties are not proportionate to the gravity of the crimes, which hinders the deterrent power of the law, and there is no real mechanism, specific mechanism of reparation or rehabilitation support for victims. The second issue that I wanted to raise, but I will be very short on this, is related to the jurisdiction of the military court. As you know, well, torture can be prosecuted by a military court that is only comprised of one civilian judge, and the rest of them are judges placed under the authority of the Ministry of Defense. So that really questions the independence and the impartiality of decisions that can be made. And this special court is also has also jurisdiction to prosecute children, which is really questionable under international law and international standards. The third issue that we raised in our advocacy related to the oversight, and as was mentioned by my colleague Sadedin, the lack of an effective national preventive mechanism, and the lack of the, the remaining of the report of the subcommittee on prevention of torture, the report that I have published after their visit in May 2022 remained confidential, which hindered the possibility for civil society to know precisely the findings of the UN and to be able to advocate on these findings. But on this, Restart Center and CLDH, our partners, are already providing support to victims in detention. They have access to places of detention, and that allowed us to document under international standards, so the Mandela rules and the Bangkok rules, that allowed us to document the shortcomings and the poor detention conditions that are visible in Lebanon in detention. And we have documented that these conditions are actually amounting to ill treatment, to serious ill treatment. Detainees do not have enough water to drink, they do not have enough food to drink, to eat. That was also presented by both of my colleagues with very specific cases and examples, but these are things that we also documented. So I think the key word here is really systematic. This is something that we observe in whole Lebanon detention centers. But as was also mentioned before, Lebanon is part of the OPCAT, the optional protocol to the Convention Against Torture. And so that means that they have an obligation to establish the national preventive mechanism. So in Lebanon, this mechanism exists. It's placed under the authority of the National Human Rights Commission, but it is not operationalized. It has been only operationalized by organizational decrees at the end of last year. But to this day, it remains under-resourced and understaffed. That means that the 5 members comprising this commission, they do not have the adequate resource to conduct visits. And also, which that is not compliant with the OPCAT, but they do not have the right to do unprompted visits. They must have a clearance letter. That means that the authorities in charge of the penitentiary system, they can act when they know that a visit is coming. They can maybe change their practice, and they can temper what the actual behavior with victims and detainees is. So we really advocate here for unhindered access to places of detention and for real operationalization and resources for the national preventive mechanism in Lebanon. We also advocate for the UN subcommittee report to be made public so that everybody can really be aware of the issues at stake and the overcrowding, the pre-trial detention actually affecting 70% of detainees in prison. So that means that 70% of people in detention did not undergo a trial. They have barely seen any judge, and there is no legality decision on the fact that they are currently in detention. We advocate for all of this to cease and for the international norms and standards to be correctly implemented. This is what we advocated to the missions, and out of the more than 300 recommendations that were issued to Lebanon, we actually had more than 40 recommendations addressing those 2 issues. Some of them have been shown by my fellow speakers, but we are really happy to see that a lot of recommendations tackled the effective national preventive mechanism and the independence and effectiveness of the justice system. Of course, those recommendations are not enough, and we will see how they are implemented in the future. But I do hope that the state of Lebanon has really understood the magnitude of this issue and will act accordingly to improve things in the future. And because implementation is actually a key topic and a key subject, I'm now moving on to the second part of my presentation, focused on the survivors-centered approach. Because we believe that implementation should be guided by survivors' rights and by survivors' voices. This is where the IRCT, the UATC, the United Against Torture Consortium that we are part, and the support of our members came into place. Because in March 2026, during the previous session of the Human Rights Council, we published this charter, which is the Charter of Rights of Victims and Survivors of Torture. It's a joint document that we published with the UN Special Rapporteur on Torture, and that is built around 7 core principles and issues, really shaping the vision that survivors have of rehabilitation, of international support, of international engagement, and of justice and accountability. You will find some extra copies of the charter at the entrance, and I'm also happy to share the charter in other languages. We have it available online in all 6 languages of the UN. But this was really a landmark document. It was not another document just about survivors. It was really a document that we drafted with survivors. We conducted hearings in 3 different regions. So in Asia, in Kathmandu, in Africa, in Nairobi, and also in Latin America, in Bogota. And then the Special Rapporteur also issued a call and received more than 120 submissions from survivors to describe for them what would a system that takes them into consideration look like. And so we are really happy of this outcome. We are currently in the process of disseminating this charter, making sure that people are aware that this document exists. And we are also building activities with survivors right now to really turn this document into more than a policy paper, but really into a living document. As you also know, the UN Charter, the UN Convention Against Torture, and the General Comment on Article 14, the article providing for the right to redress, puts a duty and an obligation on the member states, which is the obligation to provide as full rehabilitation as possible and to provide adequate compensation for the crime of torture and ill treatment. But in Lebanon, unfortunately, to this day, there is no national reparation system or program available to victims. This is also something that we have heard from survivors that really can make a difference. But in Lebanon currently, that means that the state is not providing the psychological care or the livelihood support or the medical, examination, but also care that survivors and victims need to be able to move past their trauma and to overcome their status and their situation as victims. So that's also something that we advocate on. And I also want to once again shed light on civil society that here closes the gap between the absence and the lack of action from the state and what is the standard and what should usually, ideally be put in place. Here we have centers such as Restart, such as CLDH, such as the 2 centers from my colleagues, Cedar Centre, providing this medical attention, providing this psychological care in forms of individual sessions, group sessions, but really making sure that survivors are included and that they have the right tools to be able to regain their dignity. This is also why the word survivor-centered or victim-centered cannot only be a slogan. The recommendations that we secured now in Geneva for the UPR of Lebanon, they should be implemented in a way that is survivor-centered. That means that they should be implemented with the consultation of survivors and victims to make sure that we are doing the best thing possible and to make sure that we are not creating another system that is full of shortcomings and that, although it's full of good intention, falls short when it comes to implementation. So here, in that specific avenue, I believe that the help of civil society can also bridge the gap and really bridge the communication between the state authorities and the victims and survivors. Before concluding, I would like to emphasize good news, a positive note. It's not relating specifically to Lebanon, but earlier this year, in February, in Guatemala, there was the launch of a national reparation programs for victims of armed conflict. And this is really a good example, actually emphasizing the charter, well, even before we published it. Because this program was built by survivors. There were national consultations organized with the states, with the state and with victims associations and with victims themselves, not only their representatives, but with victims of the armed conflicts themselves. So this program is actually really holistic and comprises different forms of reparations as dictated by the general comment of the UN Committee Against Torture. This program comprises financial compensation, material restitution, psychological care, a mechanism to search for the disappeared, historical memory, and guarantees of non-repetition. So as you can see, it's really holistic, and it addresses all the aspects of what is lost or what is missing when we have suffered from torture and from ill treatment. So that means that it's possible when there is political will and when there is sustained civil society engagement, when there is consultation with survivors of torture, it's possible to do great things. Now, of course, the program has been launched in February. We are only in June, so it's too early to assess the implementation, but at least we can see that we are on a good path and we are on a good track for this in Guatemala. So I can only wish that something similar in terms of programs and in terms of designing in consultation with victims can happen in Lebanon. I think it's really a demonstration of the charter provisions in practice. And it really also embodies the motto, the slogan that we have at IRCT, which is nothing about us without us. It means that at all stages, victims and survivors of torture needs to be included and needs to be featured, their voices need to be heard. This is also something that is really emphasized in the charter, so I hope that you get a chance to read it. You will see that it's written by survivors and it really emphasizes the fact that they want to be agents of their own change. Thank you very much.
Thank you very much, Maeva, for these important recommendations, and also especially for reminding us that having an open civic space is a prerequisite to be able to advocate, follow up, and implement such recommendations, and to be able to have the participative inclusion of victims and survivors. And with that, I move to our next distinguished panelist. I'm pleased to introduce Mrs. Samira Mouassi, who will tell us more about the role of civic space in advancing human rights, accountability, and the protection of human rights defenders. You have the floor.
Thank you very much first for this invitation to speak on the occasion of the International Day in support of victims of torture, and to speak precisely on an issue that lies at the heart of the human rights system, the civic space. So my presentation will be focusing on international standards that are important to take into consideration, that I hope it can contribute to the discussion today. Civic space is often described in legal terms grounded in the freedom of expression, association, and peaceful assembly. And in practice, it's much more than a legal framework. It's an ecosystem, one that enables participation, that ensures access to information, protects independent voices, and creates the conditions for dialogue and accountability. At its core, an open civic space allows people to take part in decisions that affect their lives. It ensures that diverse voices, including those too often excluded, are heard, and that their contributions can shape policies and governance. So in doing so, civic space becomes indispensable to the realization of human rights themselves. But civic space is not only about participation, it's also fundamental to accountability. When civic space is open, victims can access legal support and advocacy. Independent actors can monitor detention facilities, document abuses, and engage in oversight processes. Complaints mechanisms function and violations are brought to light. But when civic space is restricted, the opposite happens. Monitoring weakens, reporting declines, victims are silenced, and perpetrators operate with greater impunity. Civic space is therefore not only a space for engagement, it is a safeguard against abuse. It also plays a critical role at the international level. Civil society actors and human rights defenders engage with UN mechanisms, including the Universal Periodic Review, the special procedures, and treaty bodies, providing essential data, testimonies, and analysis. These contributions are central to the credibility and effectiveness of international accountability processes. Without them, global scrutiny risks becoming disconnected from realities on the ground. Civic space is equally essential as a prevention tool. Open civic space allows early warning of human rights risks. It enables civil society actors to identify emerging patterns of violations and raise alerts before situations escalate. It supports timely responses, including preventive diplomacy and protection interventions. When this space is restricted, early warning systems begin to fail. Threats go under-detected. Information gaps widen, and systemic abuses become more likely. At the center of all of this are human rights defenders. Human rights defenders monitor and report violations. They advocate for legal and policy reforms. They empower communities and facilitate participation. They connect local realities to global mechanisms. And very often, they are the first to raise the alarm when rights are at risk. Importantly, human rights defenders are both beneficiaries and guarantors of civic space. They depend on it to operate safely, and at the same time, they actively defend and expand it. Protecting them is therefore not only a legal obligation, it is a strategic necessity for sustaining accountability systems. Internationally, the protection is grounded in well-established frameworks. The UN Charter, the Universal Declaration of Human Rights, and the international covenants together form the foundation of the international human rights system. The 1998 UN Declaration on Human Rights Defenders further affirms the legitimacy of their work and the duty of states to protect them. At the institutional level, the Human Rights Council, the special procedures, including the Special Rapporteur on Human Rights Defenders, the Universal Periodic Review, and treaty bodies all contribute to monitoring, protection, and accountability. These mechanisms are reinforced by regional systems and supported by the work of OHCHR globally. Yet, despite this framework, we are witnessing a concerning global trend, the shrinking of civic space. Across contexts, restrictive laws, surveillance, digital repression, and attacks on human rights defenders and journalists are limiting civil society's ability to operate. The consequences are profound. Monitoring declines, investigations are obstructed. Victims lose access to support. Engagement with international mechanisms becomes more difficult. Ultimately, accountability weakens and impunity grows. Beyond accountability, shrinking civic space also affects governance, peace, and development. It reduces transparency, undermines trust in institutions, and limits the ability to address grievances constructively. This is why civic space must be understood not as one human rights issue among others, but as a cross-cutting enabler. It is a central pillar of an enabling environment, one that allows documentation, reporting, and advocacy to function effectively. When civic space is open, information flows, accountability mechanisms are activated, and reforms become possible. When it is restricted, the entire system is weakened. Therefore, the message is clear: civic space underpins participation, accountability, and prevention. It strengthens the rule of law and supports more inclusive and resilient societies. Thank you.
Thank you very much. Now we can move to our final speaker, Michael Kambara from Geneva, his Geneva representative from the Gulf Center for Human Rights, to discuss our main event today, the Lebanese Fourth Universal Periodic Review. What are the outcomes, the international follow-up, looking at the future, how can we follow up on the recommendations? Michael, you have.
Good morning, and thank you all for being here. It's a very warm day, so I will hopefully get through this as quickly as possible so we can all have something cool to drink. I want to talk about just what the actual UPR is. We talk about it as if everybody knows it, so I just want a couple of words to start with that. It's called the Universal Periodic Review, and every state undergoes it about every 4.5 years. It's a UN mechanism where 3 states are selected to review each state. So everybody has to do 3 states at some point. And the idea is to have a process at the end of which all states can provide recommendations to that specific state on things that they can do to improve their record of human rights. Now, as you can imagine, with 180 states, there are about 45 every year. And for example, this session, there are 12 states that are undergoing the adoption. So it's a real machine of recommendations that goes through. But I think what's really important about this is we've seen what happens at the national level in Lebanon. We've seen the failure to stop torture. We've seen impunity. We've seen that there are sometimes laws on the books. Sometimes there are not sufficient laws on the books. But what's happened is there is not sufficient pressure for accountability. And again, that's one of the words we use here in Geneva. Let's remember what that means. That means if somebody tortures you, they should be punished. They should go before a court. They should be convicted if they're guilty, and then suffer serious punishment. That's what we mean by accountability. So what does this UPR mean for all this? This means that the international system has reviewed Lebanon, provided some recommendations, and these are tools that hopefully can be used to follow up by national actors, international actors, that give us the tools to say, look, either you accepted these recommendations, which means why aren't you fulfilling them, or you noted these recommendations, which is a very polite way of saying you rejected them, where you can turn around and say, look, states suggested that you do this, and we want to know why you have rejected this. So I want to go through a little bit the Lebanon UPR and talk about this. I'm going to start with the fact that there are 286 recommendations. And I think it's very important when you look at recommendations, you have to look at the individual quality and specificity of recommendations. If you say something along, if a state says something like, we encourage you to improve the state of human rights defenders. Encourage, okay, they can say we feel encouraged. So you have recommendations that are very what we would call soft balls, very easy to catch. But then you have recommendations that have a bit more teeth in them, and those are the ones that I think are the more interesting ones. So when somebody says how many recommendations the state has accepted and how many are noted, that's important, but that does not give you always a clear picture. So let's go into some of the details. And I'll just say that the Gulf Center, along with IFEX, OMCT, and Maharat, we provided a stakeholder report. And what we did was we looked at freedom of expression, freedom of assembly, we looked at the media law, we looked at migrants, and we looked at women. I'm going to start with torture, but I'm going to talk about all of these as examples of what the UPR can be used for. So, in theory, the Lebanese government have done, they've accepted 10 of the 11 recommendations that address torture. But the one that they did not accept was actually one from Germany, which was recommendation 107, which was to revise, and it says Act number 65, but I think they're referring to the law 65 that was mentioned by colleagues, to abolish the statute of limitations on torture and ensure exclusive civilian court jurisdiction. This is from Germany, and they hit actually two of the main points that were covered here today, which is the statute of limitations, which Maeva explained why 3 years is insufficient, and of course the whole idea of using military courts to try civilians, which is always a bad idea. That was noted. which means they did not agree to do that. How can you use this tool? As I said, you can say, dear Lebanese government, this was a recommendation. Why did you note it? And although it's a 4.5-year process, in 2 years already, the government of Lebanon is going to have to make a midterm report explaining how its implementation in preparation for the next cycle. As I said, it's a machine that just keeps going. So on the one hand, they've agreed that torture shouldn't happen. This includes mentions of the National Human Rights Council and access to detention sites. And I think Maeva pointed out the need to have unexpected visits. And as a former delegate of the International Committee of the Red Cross, if they know you're coming, they do dress things up in any detention site. So you need unexpected visits, you need to be able to repeat them, and you need to be able to talk privately with those affected, with your own translators. But I'm going a little beyond there, that's more historical. So in other topics, the Lebanese government also does quite well in terms of the UPR. So if you look at freedom of expression, there were 10 accepted, there was 1 that was not. There were 10 that looked at media, 5 of them very generally, and 5 mentioning the new media law, which is still in the process of being adopted. So I'm not 100% sure where that is, but it is considered an encouraging, although imperfect, progress. What's interesting, though, is the one that they noted rather than accepting, because it was very specific. It's 124, and it comes from Canada. It says, abolish criminal defamation and other penal code provisions, including, and then it lists a whole series of articles, 292, 380, I won't list them all, to protect freedom of expression and media. That's where you start to see the red lines for the Lebanese government. They don't mind being told to improve things for freedom of expression, but on their terms, and don't like being told where the points are that are really effective. So I think that is something, again, that can be used for follow-up. Just as an example of some of the red lines for other UPR, if we look at migrants, there's lots of migrants working in Lebanon, many as domestic workers. So everything to do with the legal conventions that protect migrant workers and everything to do with the kafala system, those were not accepted. Everything else about treating people well, about avoiding trafficking, those were accepted. That's good. But for migrant workers, there are still some challenges. And maybe just a last point on women. There were a lot of recommendations, 41 out of the 286. Anything to do with supporting the stopping of trafficking, general statements on discrimination, domestic violence, empowerment of women, that was all accepted. But what was noted was anything to do with increasing obligations under the CEDAW, the discrimination against women, and anything to do with allowing women to pass on the nationality to their children if their husbands are not Lebanese, obviously passing on their nationality. So there again you see the red lines. So now you can then, so just as a final thought on torture, and just to connect some of these points of civic space, we work on freedom of expression and freedom of association. What that means is, though, unfortunately, when a state wants to stop this, they use torture as one of the tools used to repress freedom of expression and freedom of association. And I think that connection is always important. Many human rights defenders who've been tortured are because they have spoken out and said things that the authorities disagree with. I'll be happy to take questions along with everybody else, but I think I will stop there because my 10 minutes are up.
Thank you very much. Perfect timing, Michael. Yeah, I think for the sake of time, you can move directly to any questions, comments by our guests in the room. If you want to ask any questions, please raise your hand or a comment. Otherwise, we can move for final. Yes, please. He will bring you. راح يعطيك الميكروفون. شكرا.
Hello. Allow me to speak in Arabic. It's okay.
Of course, of course.
Okay, thank you. أنا رئيس جمعية الصداقة الأوروبية العربية. وظيفتي السابقة كانت رئيس مدير المركز السويسري لدعم الديمقراطية والحريات العامة بزوريخ. أول شيء أنا بحب حيي الأستاذ محمد صبلوح على شجاعته وعلى وقوفه ضد الدولة العميقة بلبنان. وكثير لبنانيين، معظم اللبنانيين بيعتبروا الأستاذ محمد صبلوح بطل عم بيحارب باللحم الحي ضد هيدي المنظومة، رغم أنه عم يتعرض لكل أنواع التهديدات والإخضاعات، ولكنه عن جد أنا بحيي على شجاعته. بالنسبة لزملائي بالمركز السويسري للدعم الديمقراطية بيخبروني أنه هن عم بيتابعوا عن كثب المخالفات غير القانونية اللي عم تقوم فيها المحكمة العسكرية بلبنان، وأهمها قضية الفنان فضل شاكر. الفنان فضل شاكر رغم أنه برئ من كل التهم التي كانت موجهة إليه، الفنان العالمي فضل شاكر يمكن حضرتك تعرفيه، ورغم أنه مفوض الحكومة لدى المحكمة العسكرية بلبنان طلب الإفراج عنه، برغم أن كل الشهود أثبتوا براءته، إلا أن رئيس المحكمة العسكرية وسيم فياض لا زال مصر على الإبقاء على اعتقاله، رغم أنه الفنان فضل شاكر اليوم مريض وهناك لجنة طبية مكلفة من الحكومة اللبنانية بالإشراف بفحصه، أثبتت أنه الفنان فضل شاكر مريض كتير وحالته الصحية يعني تعبانة، ممكن أنه يموت بالسجن، ولكن رغم ذلك رئيس المحكمة العسكرية وسيم فياض عم يرفض الإفراج عنه. وسيم فياض رئيس المحكمة العسكرية مقرب من حزب الله، وبالتالي هو عم ينفذ هون سياسة حزب الله، وهي إخضاع وقهر وسجن كل من يعادي منظومة حزب الله بلبنان. نحن بنشوف إنه إذا استمرت هيدي الحالة واستمرت المحكمة العسكرية بإخضاع وإذلال كل خصوم حزب الله بلبنان، علينا حينها أن يعني نفكر بطريقة لوقف هذا التعدي على الحريات بلبنان من قبل المحكمة العسكرية. يجب علينا بالفعل أن نعمل على إدراج المحكمة العسكرية أو المشرفين عليها للائحة العقوبات أو للائحة دعم الإرهاب، لأنها بالنهاية عم تدعم حزب الله. وآخر شيء نحن بنقول الدولة اللبنانية إنه يجب على الدولة اللبنانية أن تعلم بأن قوة الدولة تنطلق من تطبيق العدالة، وتطبيق العدالة تطبيق القانون، يعني تطبيق القانون يأتي من تطبيق العدالة. ما فيها دولة تكون غير عادلة غير قوية إذا ما كانت تطبق القانون على كل شعبه وليس على فئة معينة من شعبه. شكرا.
شكرا جزيلا. نتيح الوقت لأسئلة أخرى، تفضل. رح يعطيك الميكروفون.
يسعد أوقاتكم جميعا. أنا محمد خير الوزير، ناشط في مجال حقوق الإنسان من 2005، وبيني وبين لبنان قصة طويلة، يعني كما قال الشاعر عبد الكريم الكرمي: خلعت على ملاعبها شبابي. بالنسبة إلي كسوري، طبعا أنا المدير التنفيذي لمنظمة نبض للحلول البشرية، فهون بسويسرا. نحن بالنسبة لنا كسوريين، وعم بتكلم بفترة التسعينات، يعني كانت لبنان بالنسبة لنا هي المنفس، يعني نعتبرها نحن مجال الرأي الحر والكلام الحر، ونشعر فيها بالأمان لما نطلع من سوريا للبنان. شو اللي تغير، شو اللي صار عبر هالسنوات الأخيرة اللي تحولت للبنان لدولة قمعية أكثر حتى من سوريا. يعني ولو كان هذا الشيء يعني بالنسبة لسوريا مفضوح، كونه اجت فترة الحرب اضطرت الناس، يعني عطت مساحة كبيرة لأنه يظهر شيء كتير على الإعلام، وكتير وثائق، وكتير تتسرب أشياء، وبعد سقوط النظام تبين أشياء كبيرة. بلبنان لا زال هذا الشيء مخبأ، ولا زالت إلى مرحلة، يعني أنا بذكر بدي أتكلم على شغلة حدثت بال2016. خرجت بعثة سويسرية مكونة من بلا 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 وفلان وفلان وفلان، أسماء كبيرة من سويسرا يعني بعرفهم شخصيا، وخرجوا إلى لبنان لمعالجة مسألة السجون. فعادوا إلى هنا، وهذا الأمر اللي عم بحكيه أنا موجود، يعني بمجرد بحث بسيط بيطلع بتقرير انه سجون لبنان مثل ما تكلم الاستاذ محمد صبلوح، وبين قوسين في لنا صديق مشترك دائما بيبعث لي رسائل بيقول لي دير بالك على محمد صبلوح وقول له يهدي شوي خايفين عليه. تحيه لصديقنا المشترك وتحيه لمحمد صبلوح اللي ترفع له القبعات. فرجعت البعثه وكتبت تقريرها انه السجون اللبنانيه سجون مثاليه. طبعا انا بسويسرا وبتكلم حقائق وهذا شيء موجود على النت. طبعا احد اعضاء اللجنه استقال فورا وكتب تقريره الخاص انه كل اللي شفته انا بالسجون هو مسرحيه، لا اخذنا على سجون حقيقيه ولا الى شيء. هذا شيء بتاريخ 2016. سؤالي يعني شو اللي جرى لحتى انقلبت الايه من لبنان مرتع الحريات ونجاح وكيم اللي كان يوقف بالبرلمان ويحكي كلمه الحق ويدافع الى التطبيل؟ هي وحده. اثنين، بالمرحله الاخيره الان بعد تحرير سوريا، ما بتشعروا انه سوريا خذلتكم بالاتفاقيه الاخيره بالنسبه لموضوع السجناء؟ يعني ليش عملت الديل او الصفقه اللي عملتها وحاديه الجانب ما كانت شملت ايضا المعتقلين اللبنانيين اللي هن وقفوا معنا، وانا بوجه لهم تحيه وبتمنى لهم الحريه؟ يعني ليش هذا الامر اللي صار من الخذلان من الحكومه السوريه الحديثه ضد مناضلين حقوق الانسان اللي عرضوا حياتهم للخطر ليدعموا الثوره السوريه والشعب السوري؟ وشكرا واسف
شكرا
على الإطالة.
جزيلا لسؤالك. If there are no more other questions in the room, we can move for answers and final comments by our panelists. Saadettin, if you want to give a few comments.
Thank you, Chair. Yeah, I'm happy to add something in this space. So first of all, thank you, everyone.
In 1 minute, thank you. No,
1
minute for
okay,
each.
yeah.
Sorry.
Yeah, actually, just to follow up on what my colleague Mohamed was saying during his presentation on the need for forensic assessment and forensic medical evaluation. In Lebanon, there was a partnership developed between the Ministry of Justice and Cedar Centre. It was focusing really on giving the victims and the detainees present in the Palace of Justice the opportunity to meet with doctors trained in the Istanbul Protocol and to make assessment of their health. And that evidence could then be used in court. Unfortunately, this partnership has ceased, and so we also advocate for this to be renewed. It was also one recommendation of the special rapporteur who visited Lebanon in 2025, the special rapporteur on summary executions. So yeah, just to say that this is also very important, and it's something that we advocate for in Lebanon. Thanks.
Thank you. Last comment from my side that the UPR process shouldn't be as a reporting mechanism only. It should be like a chance to improve the human rights situation in Lebanon and to stop the violations that's happening.
يعني بالنسبة لموضوع اليوم الدولي لمساندة ضحايا التعذيب، أنا توصيتي أنه ثقافة العنف الموجودة داخل لبنان اللي تربيناها جوابا على الدكتور محمد خير الوزير، تربيناها من نظام الأسد للأسف. هيدي الثقافة بدنا نقضي عليها. بدنا نرجع لبنان يلي بنفتخر فيه. واليوم واجب رئيس الجمهورية، واجب الحكومة اللبنانية، واجب مدعي عام التمييز يكون في محاسبة حقيقية لمرتكبي جرائم التعذيب لنفتخر ببلدنا اللي نشر القانون بدول الخليج. شكرا.
Yes, hello. Just very briefly to echo your comments that the UPR is a tool. Use it. It's got arguments that can help you continue the process of accountability.
Thank you. Maybe just saying that hearing the testimonies this morning are very important to relate to all the contributions that UN human rights mechanisms receive from civil society actors. So we hope they will continue to reach out to the system and provide their contributions. Thank you.
Thank you very much. And as there are a lot more things to say, we invite you to discuss informally with our panelists over a coffee break, and we thank you for your presence today. Thank you very much.